Lordship. My lord, item number 16, it is fixed for hearing. But I am not getting instruction from my client since last 10 years. So ultimately, I have issued a retirement letter to them. This may be, I have taken the consent of my learned friend. This may be taken after 4 weeks, Lordship.
18 matter 4 weeks will not be possible. We'll have to have 2 weeks.
No, Lordship, I have sent the letter by registered post. So deemed service will be effective after 30 days. That's why I am praying for 4 weeks. Otherwise,
Doesn't matter. 3SP Royal Learned Counsel for the petitioner, for the appellant, submit that the clients are not in touch with him, and therefore he has issued a communication to withdraw from the case. He has accordingly paid for some time. Other side informed?
I'm for the other side, Lordship.
4 weeks.
Lordship,
Alright.
because the deemed notice date may be fixed after 4 weeks.
This matter on 30th of August.
Oblige, man.
This may come up for order next week.
What matter?
Make the regular second appeal. It was earlier listed for hearing, but now it is published. So many
Orders for what? What orders?
there is for fixing a date of my lord hearing again.
May I please, your lordship, my lord, item number 14, my lord.
1-4.
Yes, my lord. The little difficult is actually, my lord, I was out of station. So, my lord, this may be taken on Tuesday, my lord. I will do the matter, my lord.
Other side.
Other side is not there, my lord. I will inform my lord.
You take their consent, inform them, we will accommodate.
I will.
You do it, we will not passing orders.
All right, my lord. That's it.
You can send some junior of yours.
Get the matter, my lord, column.
But we'll pass orders only after that information.
Yes,
Maybe. I did to mention for listing a matter for Monday. Civil division petition.
Fresh matter.
No, my lord. For admission, my lord.
Matter of which year?
This year, my lord. There is a stay, my lord. The lower court proceeding is staying.
You for the respondent here.
My lord.
May it please, your lordship. Lordship, I beg to mention one IA, lordship. This was filed in the year 2023 by the appellant, lordship. Their RSA 89 of 2001 was dismissed for default. The RSA is of 2001, lordship.
Year for whom?
And for the respondent, lordship. Execution has been stayed, lordship.
There is a stay order. When do you want?
Lordship, there is no stay order, but the executing court is not proceeding.
When do you want?
Any date, lordship, next week.
Next Wednesday.
Lordship, oblige.
May it please your lordship. Lordship, I beg to mention item number 12. Maybe adjourn for 1 week as the senior counsel, engaged counsel is suffering from tonsil.
Who is your
MP Sharma.
MP Sharma? 15 matters. It's submitted. As MP Sharma. Have you informed the other side?
Yeah, no, yeah.
You need to mention it or informing. You're not going to pass orders. Inform them, take their consent. No, this is not the way. You are a citizen counsel, should not make this mistake. We'll adjourn it, but have their consent. Yes, Alam?
May I please, your lordship. I beg to mention for item number 13, my lord.
Yes. 35.
13, 1-3, my lord.
1-3.
1-3, my lord. My lord, Mr. Kencho, the senior advocate, will lead me in this case. But he is having some personal difficulties. I have taken caution for the other side. It may kindly be listed on next Thursday, my lord.
Free and Alam, then it counted for the president. Submit that he is being led by K. and Chaudhary senior counsel, who has got some difficulties today. He accordingly pays for some accommodation for prepare, considering that this epic is of the year 2015 come up. List the same for hearing on
3-8, my lord. 3rd of August.
3rd of August. Yes.
Much better.
May it please your lordship. Lordship, I beg to mention for listing of a MSc appeal for orders, lordship, since it is a long pending case.
You're for whom?
I am for the respondent.
The claimant.
Yes.
MSc appeal is of which year?
Lordship,
Case is of which year?
2021.
Long pending.
It was last listed on 14/2.
You said long pending.
22.
21 was also old, but not that long pending. What
Yes.
orders do you need?
It's Accident appeal is,
Understood. Why is your prayer for listing? What orders are you expecting or you praying for?
the parties are insisting us to list the matter soon.
So you don't go by the parties, you go by your own conscience. What is the stage of the case?
It is on admission stage.
You have got 50%.
Lordship?
Have you got the 50% of the award?
No, no amount. We have received.
Take your records, madam. Okay, where does the next?
Highly obliged.
Wait, please, my lord. I beg to mention for listing offense CRP, that is CRP 14/2014. It is for withdrawal, my lord. On Monday.
One or tomorrow. Every tomorrow.
Highly obliged.
Kind of withdraw.
May I please, Lordship? Lordship, I beg to mention for listing one CRP for withdrawal. Last listed on
Okay,
2/6.
withdraw either tomorrow or Monday, whenever you.
Lordship, there another matter CRP last listed on 12/12/2022. Till the
What is the stage of the case?
admission.
Oh, next week. You were there next week.
May I please, Lord? I get to mention item 4, my lord, of daily listing with the consent of other side. Matter may be taken on next week.
Here for the respondent.
I am for the petition.
Here with Mr. Das.
Yes. I am taking consent from Mr. T. Islam.
Oh.
Yesterday. only.
On a prayer made on behalf of the petitioner. Matter is returned to be listed next.
Hello.
May I please your lordship? May I please your lordship? With the consent of the other party, I beg to mention item number 15 to be fixed up to 15 August, your lordship.
Here for whom?
Petitioner, your lordship.
And for the claimant respondent.
Not a petition, it's an appeal.
Yes, sir. It's appeal.
Who is the senior? Bhatra. Who is the senior?
On behalf of RK Bhatra, sir.
Bhatra Bhatra. 21,
After 15 August, your lordship.
Fixed date maybe.
a prayer for adjournment has been made on behalf of the appellate. Full stop. Why after 15th August? This is a matter of 2018 MSc appeal.
Your lordship, my senior will be on leave. He will be available after 15 August, your lordship.
A prayer for adjournment has been made on behalf of the appellant on the ground that RK Bhatra would not be available for some days. Full stop, para. As accordingly, the matter is adjourned to be listed on 17th of August.
Much obliged.
May I please, your lordship?
Yes.
I would mention for listing, your lordship.
What
CRPIO, land matter, your lordship,
Fresh matter.
fresh matter. Yes.
When did you file?
26/6/23.
When do you want?
Tomorrow, your lordship.
You filed or? You filed yesterday.
No, yes, sir. 26/6 June or year.
You filed on June. It has not been listed.
Not yet. No.
Right. Okay, we'll have it tomorrow.
Obliged.
Attorney is appearing in this matter. Who is appearing on the other side? BD Das. Where are they? The 13 matter. What is the stage? Hearing stage.
Hearing, my lord.
Where is Mr. Das? Regular first appeal.
Yes, my lord.
You are the plaintiff.
I am for the plaintiff. Plaintiff appellant.
LCR has come. Yes. We can have this for disposal.
Yes, it is for disposal, my lord.
As per state of disposal, it may not be proper. If you want today, we can have it in the, after, there are 3-4 items. Some motion and one matter which we are fixed today at 10:30.
Yes.
Thereafter, you can take it.
No, some other date may be fixed. Then.
That's the 13th matter, we don't know to adjourn, and it is on the top of the list.
Yeah, I am ready.
I know. If we start this, take a lot of time early in the morning.
Maybe,
And
maybe taken at 2,
we'll try it.
my lord.
Please inform Mr. Duff.
My lord. Mhm.
Item 2.
Last year, 600. That's great.
Yes,
Lord, I have received the instruction, my lord. As per my instruction, my lord, the department contents that, my lord, the last year is 2016. And in 2016, there were 8 students, my lord. That is why it was not considered. That is the stand of the department, my lord.
what was the observation of the score?
Observation
In the order
was that
listed.
2017 is the last year of,
Yes. In paragraph 18, this score-
paragraph 17 of the order, my lord.
yes. What do you say? Instruction.
What my friend has provided is absolutely wrong misunderstanding of the authority. Last final exams is the 2017 February exams, that's all.
Yes, my lord, it would be better to bring it on record, my lord.
You will also know what is the position and you can at least rebut.
My lord, only thing, if your lordship permits, if your lordship see the provision of the act only once. And
Today, can we pass an order with the instruction? Can you find the affidavit? First, we hear with the counsel for the petitioner. Sarah. The NJ Catonier. Sending counsel. Secondary Education Department. Has produced before this court. A communication. Before this court, written instructions. For written instructions transmitted by communication dated 23/6/2023. As per which the claim of the petitioner has been denied. Sarah, this court is of the view that the stand of the department we put on an affidavit so as to enable the petitioner so as to give an opportunity to the petitioner before a fair discourse, before a fair adjudication. We can retain this.
Yes, my lord.
Let such affidavit be filed within a period of 3 weeks from today. You fix the date,
yes, ma'am.
list on on 21st of August,
Or 23, my lord,
23rd of August.
Oblige, lordship.
deeply obliged.
May I please your lordship? Lordship, this is a transfer petition praying for transfer of a money suit from the civil judge senior division Dimapur to any.
I got a copy, my lord. That part.
Transfer form? Transfer form?
May I please your lordship?
Transfer from where?
Transfer from senior civil judge senior division Dimapur to any competent court in the Assam, my lord. Maybe it Guwahati or in Karimganj, as because the majority of the transaction has been completed in Karimganj. My lord, the brief fact of the case is that, my lordship, the petitioner is a distributor of the respondent number 2, working in since 2016 in Karimganj. And my lordship, after receiving the summon, my lordship, summon at page number 33.
You are the plaintiff.
My lordship, I am for the plaintiff. I tried to appear before the court, my lordship, in Dimapur, my lordship, but because of the hostile circumstances created by the respondent number 2, my lordship, and my life threatening because I could not appear, my lordship, there. I've been there in Dimapur, my lordship, on the date of the date fixed for the appearance, my lordship. Even I could not engage my counsel, my lordship, because some guns are behind me, my lord. I have annexed my railway ticket also, my lordship. Page 33, my lordship, is the summon, my lordship.
So you are not the plaintiff. You said you are the plaintiff. You are the defendant.
My lordship,
You are the defendant. in
my lordship, I'm the defendant in this money suit, my lord.
Plaintiff.
I'm so sorry, my lord. I didn't hear it.
You have received notice thereafter you tried to appeal.
Yes, my lordship.
You are facing difficulties in appearing.
Yes, my lordship.
Where have you stated?
My lordship, I have annexed this.
Where have you stated? Let us see your statement.
Yes, my lord. My lordship, para number 6, my lordship.
Paragraph 3.
Yes, my lordship. Page number 6.
Let us see how you verify this state.
My lordship, kindly see, my lordship, someone is page number 33, my lordship.
Let us see your verification.
And after that, my lordship, the railway ticket is my lordship.
Let us see your verification first. Paragraph 6 has been verified as true to record. Your life threatening by some person who following you becomes part of records. That is how you verify your statement. Such serious allegation. Do you know the importance or significance of a verification in the affidavit? In a proceeding of this nature?
I have also stated in the grounds also, my para number 9, my
You are
lord.
not on the ground, you are on the statement of fact. You said that you have been threatened and you verified it as part of being part of record.
My lordship, I have also filed in CR case, my lordship, in Karimganj district, my lordship. Before that also, he was threatening me, my lordship, before going to Dimapur, my lordship. There is also.
Where are those statements?
My lordship, page number 34, my lordship.
30?
34, my lordship. That is before going to the Dimapur, my lordship. There also they are threatening, my lord. Page number 35, my lordship, third paragraph. I have categorically stated, my lordship, threatening is there, my lord.
This is a different proceeding, Mr. Counsel.
My lord.
We are not connected with that proceeding which he had instituted at Karimganj. We are in a proceeding which is a Dimapur.
my lordship. Dimapur, they have filed the money suit, my lordship.
What have you shown to demonstrate that the court at Karimganj will have jurisdiction? Where do you stay?
Bishop, I have stated in my paragraph.
Where do you stay? In Chain-
I do stay in Karimganj, my lord.
Where does the cause of action arise? Cause of action has arisen where?
My lordship, the transaction and the business were carried out in Karimganj, my lordship, and all the transaction money is transferred from the Karimganj itself, my
Let
lord.
us see. Where have you stayed?
Para number 2, my lordship.
Paragraph 2.
Paragraph 2, my lordship. Fifth line, whereby the petitioner was entrusted with the responsibility as a distributor of sweetie confectionery for the district of Karimganj, Assam. And accordingly, the petitioner discharging the responsibility of distributor of sweetie confectionery and continued to the same till 2022. But in 2022, violating the terms and conditions of the said business agreement, the respondent number 2 had seized the distributorship of the petitioner and entrusted the same on Bikash Jain, whereby the cause damage to the petitioner an amount of rupees 30 lakhs. As such, there were some dispute between the petitioner and the respondent number 2. Be it mentioned here that on several occasions, the proprietor and respondent verbally assured to sort out the issue. Dispute.
Yes, madam, what do you say? Anything, you are a performer.
My lord, if a notice has been issued to the parties, my lord, I think that will be good.
What is your name?
Because he
Your
also.
name?
My lord, D. Hussain, my lord.
You have to counsel for the petitioner who, by means of this petition, filed under section 24 of the CPC, has paid for transfer of the proceedings in money suit number 14 of 2023, pending in the Senate Court of Civil Judge, Senior Division, Dimapur, in the state of Nagaland, to any competent court, either in the district of Karimganj or in Kampur. That's full stop. The petitioner is the defendant in the state to full stop. Sarah. It is submitted that the petitioner, that the plaintiff has created hostile circumstances which would prevent the petitioner as defendant
He could have gone to the authority also there, my lord.
to
These
defend
are the things. If
his case. Did you lodge any police case?
No, my lordship, because somehow I escaped, my lordship. Now,
The council has also submitted that he has, that the petitioner has also filed a writing suit.
money suit, my lord.
Money suit against the respondent at Karimganj.
Petition.
Issue notice. Written by. I must speak pro state council of the state of Nagaland accept notice on behalf of respondent number 1. That extra copy be served upon her by tomorrow. That step is taken for service of notice upon respondent by registered certificate by the learned council raised for an interim order for stay of the proceedings. The government made in support of the ground No, as the government means me and the ground, on ground hours have been very put up. After consideration of the day, comma. This is directed that interest of justice would be served if further proceeding of the connected monies are kept in a bed till the returnable date. Accordingly, it is direct that further proceedings of punishment number pending insurance shall remain suspended till the returnable date. For the 6 returnable on, we put a date. 6 weeks बोला था. We'll have it on 1st of September.
Highly obliged, my lordship. I'm grateful, my lord.
May it please your lordship, lordship, kindly take up the matter after some time, lordship.
Not after some time, we will not take up this.
Lordship,
We'll leave it for any other bench. We have checked.
lordship. Obliged.
Put out.
My lord, before my good friend starts with, your lordship may look into one thing. I will raise a preliminary objection to the maintainability of the petition. Because my lord, your lordship may look into the cost title. It is read with 115, read with 151, read with 227. So my lord,
Is that the only objection?
no, my lord, not only that. Another objection is this. My lord, one order, they have challenged 4 different orders of us. One order was closing of witnesses. One order was of order 16, which was rejected. One order was of transfer of the court. One order was of review. 4 different orders in one single revision. Other merit, I will place it before after.
First objection, perhaps we may overcome. We can treat it as 227.
My lord,
But
but
if 4 causes of action, how can you file one? Okay.
My lord, so far with regard to the first order itself, my lord, 9-6 has been the order, wherein, my lord, I am the petitioner, my lord. I have a right to prove my own case, my lord. Now,
No,
on,
you're not on the merit. You have bundled 4 orders and.
yes, my lord, we have challenged the 4 orders because with regard to the same, my lord, the petition, my lord, orders were passed. This was again put up before the learned court, pointed out to the learned court, and with the same order, my lord, again it was not entertained. Again, a review application was filed. Again, it was not entertained, my lord. In that view of the matter, we have challenged it, my lord.
You want to say that it arises out of the same order?
Absolutely, my lord.
The root is
First
the-
order itself.
the root is the same.
Absolutely, my lord.
And the other orders are only consequential. in nature.
Consequential.
Okay, let us see.
Yes, my lord.
We'll hear you, Mr.
my lord, only the first point that your lordship will say that take it in 237. With due respect, my lord, subject to all my, my lord, 115 and 227 are 2 different.
No, you are correct. Legally, you are correct, but we may treat this is 227.
You have to,
It is not correct to have both the provisions together. Either it can be
neither it
227
can be
or
converted.
115. We can have it as 227. Because 115 we have a
yes.
limited power. 227 we can.
Yes, ma'am. Let it be.
Let us see.
Yes, may I take your lordship to page 14, wherein a guardianship case has been there and been filed, my lord. And
14.
yes, 14, my
You
lord.
are the wife.
I'm the wife and having the
The wife and first party.
yes. And my lord will kindly come to page 16 now at paragraph 10.
This is for guardianship.
Guardianship, my lord. Paragraph 10, my lord, if your lordships comes to paragraph 10, specifically I have stated with regard to his illegitimate relationship and everything about it. Apart from that,
Page 16.
page 16, my lord.
Okay.
And in the next page, paragraph 17, specifically stated with regard to Sewali, Basumatari, so and so, my lord.
Okay, doesn't matter.
My lord, on that very basis, my lord, the trial with regard to interim custody, my lord, it's been given to the petitioner. I take this honorable court to the interim order wherein he wants the other side, the father wants the visiting rights. We have no objection to that.
Where is that order?
Yes, I take this honorable court to page 36, my lord.
36.
36, yes. And this is the order, my lord, heard both sides. Petitioner has no objections, my lord. Second line from bottom, my lord. I didn't object to it because for the welfare of the child, love and affection of both the.
36.
Yes, page 36, my lord, order dated 25/2/2019, my lord.
Yes, where are you reading?
Heard both sides. Petitioner has no objections, my lord. He wanted visiting rights, my lord. I have no objections to that.
Where is no objection?
Heard both sides. Petitioner has no objection, my lord. I am the petitioner.
Page 36.
Yes, my lord.
Okay, or second last paragraph.
Yes. According prayer is allowed as per the petitioner birthday will be celebrated in school, so and so, so. I have no objections, my lord. Subsequently, there has been hue and cry with regard to this, my lord. There were development. Subsequently, an order has been passed again, my lord. He wanted to forcefully take away the child. That is at page 43, my lord. Page 43.
How old is the child?
Child is about class 6, my lord, about 10, 11 years, my lord.
Male child?
Only child from my side, my
Male child?
male child, my lord.
Son. Okay.
Page 43, my lord, will kindly come 3/5/2019. This is an explicit order wherein he wants to take the custody of the child. Everything has been recorded out here. Ultimately, my lord, the court, trial court below didn't interfere with the interim order, giving him all the visiting rights. And I have never interfered with regard to going with the father or otherwise assist from the father, my lord. Now, everything comes in, my lord.
Custody has been denied, but visiting rights.
Yes, yes, everything, my lord.
Visiting rights maintained.
Absolutely, my lord. And the everything started, my lord, where I filed my evidence. Now, here is a case wherein, my lord, that issues and document stage was never been followed. And the case was posted for evidence. Prosecution witness, the petitioner filed her evidence and another, her sister evidence
Two
on affidavit.
evidence.
Yes.
Two PW.
But sister, because of personal reason, could not come out. And so, my lord, may I take this honorable court to the evidence that has been filed, my lord? That will be very important, my lord.
And then what has happened?
And my lord, first, my lord, page 78. Once have a look in this, my lord, because that order I will be coming into. Page 78. This is the evidence of Poonam Mahanta, mother, my lord. And if your lordships come to page 80, my lord, paragraph 9, she specifically stated with regard to this Sevali Basumatari, two illegitimate children, in which school they are reading, class, everything has been mentioned. Now, coming to 3/6, my lord, that is very important, my lord.
Page.
Yes, my lord. 9/6, my lord. 3/5, yes. My lord, page 45, my lord, will kindly come.
45.
Yes. 45. This is my petition, my lord. The instant case is fixed today for cross-examination of the prosecution witness. That PW2, Meenakshi Mahanta Brahmo, could not adduce her evidence in the instance case. The petitioner filed this petition before this honorable court for allowing her to file evidence of her younger brother, namely Sani Monto, as PW to prove her case. Next paragraph, my lord. The petitioner states that the respondent is maintaining illicit relation with one Sevali Basumatari.
Okay.
Further, as for information, so and so, so and so. Now, the prayer portion, my lord, is being stated at page 46. It is with regard to PW3, and thereafter PW4 will come, as because there is no list of witnesses. Now, this petition was preferred on 3/6. On 3/6, there is no order, my lord. Date was posted on 9/6 for orders. My lord, 9/6, my lord, no order was passed, my lord. PW3 was cross-examined, and PW2, PW1, my lord, was partly cross-examined, my lord, because her cross-examination was continuing one.
On 9/6.
On 9/6. Thereafter, this the case was posted, my lord.
9/6 PW1 was examined.
PW1 was further cross-examined, my lord. Previously, she was examined, cross-examined, my lord. For it was again, my lord, fixed for further cross-examination.
Okay.
So on 9/6, she was further cross-examined and discharged.
And
PW3 was also cross-examined.
brother,
My lord. And thereafter, this 9/6 order, my lord, was been passed.
9.
9/6, my lord. fixing 23-6, my lord, for closing the evidence and for argument. My lord, kindly see the order, my lord. This petition, this order has been challenged, my lord. Opposite party is page 47, my lord.
This is 9-6.
9-6.
Your institutor should when 18.
18, my lord.
Okay.
Seen the petition file, petitioner Puller is present, the opposite party so and so is absent, which states. Seen the petition file for him being petition number so and so allowed after it being considered. The evidence of PW3 submitted by the petitioner in respect of Sunny Monto is accepted by dated 3/6, 2023. The copy of the evidence was also furnished to the opposite party according PW3 is present, cross-examined and discharged. Learned counsel for the petitioner submitted a petition number 905/2023 dated 3/6 is pending for hearing on the premises that by this petition, the petitioner required to be allowed for filing evidence of her younger brother, namely Sunny Mohanto, PW3. The opposite party, however, has not raised any objection in earlier occasion also. According to the prayer so filed by the petitioner allowing her younger brother to depose as witness in connection with the case.
This you can skip. He's been
Yes, yes. Now, last paragraph. Now coming to the para 3 of the petition, it appears that as for information, the respondent is maintaining illicit relation with so and so, no so and so, born out of the relationship of the opposite party and so. Both the children are starting in so and so. So as such, the petition prays before the honor to direct the principal Kaziranga so and so. I perused the petition so filed by the petition under second so and so. Upon perusal of the existing material on record, this is important. It appears
this entire proceeding is the guardianship case only, isn't it?
guardianship, my lord. Upon perusal of the existing material on record, it appears to me that the petitioner has not averted any of such fact that the opposite party is maintaining illicit relation with so and out of their relation. My lord, I have taken your lordship to the plaintiff itself and the evidence file. 2 children are born of so and so, my lord, so. Moreover, the prayer preferred by the petitioner is only confined to accepting of evidence of PW3. The petition is also stamped only ₹2, which reflects only one prayer. So, preferring another prayer in single stamp petition cannot be entertained. So, considering all these aspects, I am of the view that the prayer preferred by the petition in respect of directing principal so and so.
Your prayer to have the records of the school has been rejected.
Rejected.
That is the cause of
That by that manner, welfare of the child marriage is the paramount consideration. And if this record comes in, he is the father and the mother names is also there. I want to prove that fact and that has been obstructed, my lord.
And after this, you had filed for review.
I will file for review, my lord. And that is also been rejected, my.
Where is that order?
My lord, review order, my lord, I have given by way of an affidavit, my lord. Additional affidavit, I place it before the court. That is 27/2023, my lord.
Page.
Additional affidavit, my lord. Page, my lord, 151.
Yes. 151. 27.
Nothing to revisit. And my lord, before hearing me, they have been heard. Till date, I have not been heard.
Mr. Archuri said there are 2 more orders. Which 2 orders?
My lord?
He has appointed.
Yes, another order, my lord, that I am taking your lordship, my lord. After that 9/6, my lord, immediately coming to know about that 9/6 order, my lord, we preferred a petition, my lord.
Page 50.
Yes.
Petition for.
So is order 16.
That is That is with regard to, my lord, order 16 rule 3, my lord, for giving the opportunity to adduce evidence with regard to principal, my lord. That is again been rejected. And the presiding officer is retiring on 31/7, my lord.
Tomorrow is the day for the judgment.
Judgment, my lord.
Hearing argument is over. 2018 matter, evidences of the wife says that everything.
One. And one more order. What was
The order is that.
Where is the order?
Yes.
Page 50 is the order, I think. No, my lord, it starts at page
50 is the.
60 order, my lord. Page 60, 67 order, my lord.
59 is the order. 59.
23/6, yes.
Here, two petitions were
Yes.
filed. One for transfer regarding the
Yes.
allegation of bias against the
One
judge.
second, one second.
That petition I have annexed, my lord. There is no allegation as such to the court. I have given the third copy of the particular petition at page 55, my lord. And it has been specifically stated in paragraph 4 that the 23/6, the Honorable Court in the open court stated he will dispose of the matter before 31st July, which is the date of retirement. It's a fact.
No, 1020 was not there, rejected on 23/6. Where is the rejection order?
My lord, 1020.
1020, page 15, and during the middle part,
Yes,
let a copy of the petition be furnished to the other party.
yes. The
It's
page
not-
55 is the petition for transfer, my lord.
No. We are on 1020, whereby you had filed under 16(3).
16,
16 rule 3.
Huh.
petition of-
Yes,
At
that-
page 50, that was numbered as 1020
yes, my lord.
of 23. We have seen
Yes,
number.
that petition is at page 50.
We have seen it.
Yes,
And
So
page
that-
60
where
is
is
the
the
order.
order?
Page 60.
60, 60 is the order.
Okay, not 59.
Yes,
60, 67, 23.
yes.
101, where is 1020? Yes. Necessary orders on 1020. For
With regard to that,
is not a listed one.
learned court came to a view that he cannot review its own order. So thereafter, we invoke review powers.
One second. Okay. Answer.
And after that, my lord, when it has been stated that if it's already been rejected at the first instance itself, so we cannot review its own order. Then we preferred a review petition, my lord, under the CPC, my lord, and that has also been rejected, my lord. And rejection ground is what, my lord?
Just let us see 9-6, okay?
9-6.
Where is 9-6-23? At page 47.
Yes. May I read it, my lord?
They are calling full record. That petition was for calling the record of the school.
Yes.
No,
Hello?
no.
No.
It was not there.
No.
Petition is at
Petition
page 46.
46,
45 and
45.
Page 46, your lordship will look into
The
the
petitioner
prayer.
pays before his honorable court direct the principal Kaziranga Academy so and so with the record to prove the aforesaid facts as PW4. Principal with the records.
Then you again filed 1020.
Yes, my
Same
lord.
prayer.
My lord, here, if your lordship goes through this petition, my lord, it's been in the body of the petition with regard to that has been mentioned. But the prayer portion is PW3. Directly, we cannot go to PW4. There is no list of witnesses. That stage has been not been gone through. So PW3, after cross-examination, that petition. But this order of 9-6 comes as a surprise to us. Because on 9-6, my lord.
But you can still fall back upon the order by which the review has been rejected.
Yes.
But this
Some opportunity has to be.
This prima facie we may not find fault because once it is rejected.
Yes.
The second petition also, but review ultimately have filed.
Yes, ultimately
Because
fine,
he
my
has
lord.
said that this will amount to review. So you have
Absolutely.
filed review. That has been
Absolutely.
rejected.
Absolutely.
Yes.
My lord, first of all, what they have done with the prayer for 9-6, the prayer portion and the petition at page 45. They have, what is this?
Mr. Roy Chaudhary, is it the fact that there were no date fixed for issue documents?
My lord, list of witnesses is an issue and documents are different. List of witnesses is given in the plain. My lord, if list of witnesses is not given, order 16 rule 3 will not come. Order 16 rule 1-3A will come. 3 will come. 1-3. And if 1-3 has to be given, they have to show reason. What is the reason they have? Bona fide mistake was there. In the petition, where is the bona fide mistake? What bona fide mistake they have stated? That in the list of witness cannot be in the issue and document. List of witness with the plan. And they have not stated about the principle of the college. And order 16 rule 1-3 will come. They have made a petition under order 16 rule 3. That is for paying of some expenses. They have not made a provision also. And in their prayer, in petition for examining younger brother PW3 Sunny Mahanta was there. And only in a paragraph they have given some cause. Cause cannot be the bona fide mistake. And their petition in the order 16, your lordship will look into it. Order 16 application is at page 50. 50.
Order 50.
50. Order 16 application.
Yes.
The quotation, wrong quoting of the number provision, I will not go through it. It should have been order 16 rule 1-3. It's given 3.
Doesn't matter.
Where it is, my lord, they have shown that they have made a bona fide mistake in not placing that principal name in the list of witness. Issue and documents are different. List of witness is different. Where they have reason, not a single reason.
Mr. Roy Chaudhary, the 9-6 order consideration, both the consideration, don't you think these are unreasonable? The court we think could have been rectified.
My lord, where is the prayer for calling the person? There is no prayer.
No. 9-3 has been rejected. Let us see 9-6-2023.
My lord.
At page 47.
Page 47. And first, prior to that, at page 46.
Let us see now for page 47.
My lord, with the lordship consideration, my lord. Page 45 and 46 is the
will come to page 47.
My lord. In page 48, he has said, upon perusal of existing material, it appears the petitioner has not avoided any such facts opposite making illicit relation with and out of their wedlock 2 children were now such and such. In the original petition, not
the consideration is this paragraph which you are reading.
My lord.
Now, both the consideration, don't you think the first consideration is a perverse consideration?
First consideration, my lord?
Is a perverse consideration.
My lord, if they don't make a prayer to call, because...
No, that is not the consideration. Consideration is that there is no averment, there is no evidence.
averment as regard relationship
Yes.
and that to call for the principal or the.
No, calling for the principal is a different matter.
My lord,
That is the subsequent step taken by the petitioner.
my lord.
But the basis, foundation has been laid. There is
My
a
lord,
foundation in the plain
and-
as well as evidence.
My lord, order 16 rule,
No, we are not going to the order system.
in rule 1A, your lordship will find.
We are on the consideration by which the petition has been rejected. He says that there are two prayers, 2 rupees has been paid.
One prayer is there.
One prayer, no, he's
Calling for PW3.
court fee has been, no, you
Pa-
come, you
Page 46, your lordship will find. Page 46, prayer is only calling for PW3. There was no prayer for the person to call upon. There was no prayer. Page 46.
And if that is
No,
so,
no,
my
no,
lord, what is the question of rejecting it?
Say, well, let us read the entire paragraph again upon perusal. Please read.
My lord. Upon perusal of the existing material on record, it appears to me the petitioner has not averred any of the such fact. The opposite party is maintaining a illicit relationship with surely with such
This is
and out of the
absolutely
illicit.
perverse. This is absolutely perverse.
Not what this court want to mean by saying that.
No, we don't know what the court meant. We'll go what is appearing from the order.
My lord,
What
here-
happened in the mind of the president?
Here,
officer,
this,
nobody
in this
knows.
petition, the prayer they have made,
What
they
I
have
am
allowed it.
thinking, can you know what I'm thinking now?
My lord, my lord, my lord.
My thought will be reflected in
My
my
lord, what I
order.
want to place it before your lordship. This petition was calling for PW3.
When
It
is
was
the,
allowed.
tomorrow is for judgment?
My lord,
Yes,
tomorrow
sir.
for judgment.
I have not been heard also.
My lord, after 2018, and I can place the evidence of the wife. She has said that, my lord, that everything.
We'll have this, tomorrow will not cause the judgment. We'll have this decided, within a very short time. We'll hear this, any date convenient, within a week or 10 days. Third,
My lord, regarding that they were born and they were studying in Kaziranga, this was not there, my lord. Page 14, page petition, it was not there.
what is not there?
In page 14, your lordship will find their prayer application. It was not there in the petition.
Page 16, paragraph 10.
Page 16, para 10, my lord.
Paragraph 10, middle paragraph. You are
That,
maintaining an illicit relationship with the mother.
and where it is written that it was studying in Kaziranga and principal has to be brought.
Is it required?
My lord, they are calling under order 16.
Is it
And,
required?
my lord,
Thereafter, you come to page 36. You come to page, where is it? Page 78, at page 80, paragraph 9.
Yes, my lord.
Paragraph 9. You're in the evidence
Absolutely, it has come.
has been put in detail. In the plaint, you need to.
my lord,
follow the
now I want to
foundation.
make one submission before lordship. They had from
No,
9,
Why are you so shy to have the record? You don't have a illicit relationship, you don't have 2 children, let them bring,
Absolutely.
you disprove it.
because from 2000,
Why are you so afraid?
my lord,
After all, family court has to do justice between the parties.
my lord, one thing
When
your
family
lordship
court
will.
go by the technicalities, what is 2 rupees term? We fail to understand this kind of conduct of the family court.
My lord, if your lordship may look
Is
into
there,
that.
is the objective of having a family court? They
My
could
lord,
have
your
gone to
lordship may
civil
just,
court.
my lord,
Find out
your
the
lordship may look
technicalities.
into page 129, just for one moment.
Sorry.
Page 129, my lord.
Page?
Page 129. My lord, because this is why we are afraid. Welfare of the child, your lordship may look into the cross of the wife.
Is there a danger posed to the child?
My lord, everything is paid by me, everything has
Is
to
there a
take care.
danger posed to the child now? Is the child is in peril now? Being with the mother?
My lord, because if,
Now, we can understand, you can have the guardianship, that's a different matter. Is there any immediate danger or peril or some harm is going to be?
because, my lord,
No,
immediate.
is there? Answer the question.
Mala, the immediate danger because she is unable to, because she herself is severely in a bedridden condition. Because they have stated, she is unable to continue, look after the child.
Well,
And
we'll have-
everything has been provided by me.
But the free AK prayer comes for the petition who has filed this application under Article 227 under section 115, right with section 151 of the CPC and Article 227 of the Constitution of India against orders dated 9/6/2023, 6/7/2023 and 26/2023 passed by the learned family court. Learned family principal judge, family court number 1, Kamrup M in FC within bracket G, capital G, case number 101 of 2018. The petitioner is the first party, is the wife first party who had instituted the state proceeding under section under the Guardianship Act. It is the case of the petitioner that she does not have any objection to the visiting rights of the father, and such no objection has also been recorded in the orders dated 25/2/2019 and 3/5/2019. The case of the petitioner is that there being specific averment of illicit relationship in the claim, as well as statements made on affidavit, made in the deposition regarding such illicit relationship with another woman, out of which 2 children were also born and were studying at Guwahati, has also been stated. By the impugned order, the prayer to call the principal of the school in question with the relevant record to prove the state fact have been rejected, and subsequent, the order dated 27/2023, the petition filed for review of the earlier order has also been rejected. We are the learned counsel has submitted that the matter has been fixed for judgment tomorrow. On the other hand, Sri Roy Chaudhary, learned counsel for the, you are in KVL? Or KVL? At the KVL. Learned counsel for the opposite party husband has raised a preliminary objection on the maintainability of the petition by submitting that a petition in the present format, wherein the provisions of both the Code of Civil Procedure and the Constitution of India have been invoked, is not maintainable. He submits that the powers under the Code and the Constitution are distinct and cannot be invoked together. He, on merit, he submits that he on merit, while denying the submission, while controverting the submission made on behalf of the petition, he submits that the grounds for rejection of the petition are relevant, and therefore there is no requirement for any interference, more so when the proceedings are continuing from the year 2018 and is at the penultimate stage of delivery of judgment, which is fixed tomorrow. He also submits that the present attempt appears to be one to delay the proceedings, as the petition to call the principal of the school which record has been done at a belated stage and not with an earlier petition whereby the brother of the petitioner was thought to be introduced as a witness as PWN was allowed by the court. At that time, he submits that the present prayer would have been made and that by itself would show the lack of due diligence and bona fide on the part of the petitioner. The matter would require some deliberation. This court is also of view that the present orders, that the prayers of the petitioner is required to be considered in the proper perspective as the outcome of the same would have a material bearing in the final adjudication of the dispute between the parties. Issue notice returnable on. Give us a date for disposal.
Any date, my lord, lordship's convenience.
Tell us Tuesday or Thursday, so that you can get our adequate instructions. Today is 27.
27.
Can you have it on 17th of August?
My lord, 17th of
On
August.
17th of August.
17th.
We are not calling for records.
My
Let it be. I think this is
Well,
enough. You are not disputing any papers, I think.
My lord, only thing is this, my lord, again, my lord, my lord, calling for witnesses.
No, we'll decide that. We'll decide that issue. But no, we don't want to call for the records now.
No, my
Are you disputing any of the papers here? Since considering the stage of the matter, this court is not is of the opinion that the record may not be necessary as or as all the documents and papers connected have been filed along with the present petition and the additional affidavit. No, ready to follow Pune three PK Roy Chaudhary, Current Council accepts notice on behalf. Learned Council who has appeared on the strength of a caveat has accepted notice on behalf of the respondent number on the respondent. Let extra copies of the petition along with the additional affidavit be served upon. Para. Returnable to court also. Third, the learned council on the interim prayer. Para. Since this court has already observed that the issue involved would require certain deliberations, interest of justice would be met if an order is passed to keep the proceeding number so and so in abeyance till the returnable date. Accordingly, it is directed that the aforesaid proceedings be kept in abeyance till the returnable date. Since the matter is of the year 2000, since the petition was, since the proceeding was instituted in the year 2018, wherein the question of guardianship is involved, this court, however, makes an observation that on the returnable date, an endeavor to be made to dispose of this petition. The respondents, the parties are therefore at liberty to bring on record any other documents which may be relevant.
Yes. Deeply obliged.
Affidavit may not be required. We are not going by any pleadings. We will go by the record.
Deeply obliged.
And if we have to write third, the PK Roy Chaudhary, when it comes who has logged this caveat in respect of orders passed by the learned Principal Judge, Family Court number 1, Kamrup, and in Meet case number 101/2018. Court of TKV would be heard in the event this court proposes to pass any interim order. Court of TKV stands heard.
Deeply obliged.
Yes.
My lord, I was considering the objections, my lord. Lord, if your lordship may permit me, I'll just place a few particulars which I believe are
Yes, yes.
significant, my lord.
Yes.
My lord, recollect, my lord, two brothers were owners, out of which one brother had sold the entire property in favor of his own daughter. That was the issue. Now, my lord, on 1/3/2021, the initial order of status quo was granted. my lord.
Yes. I didn't very.
I didn't believe it. It said status quo. my lord. Now, my lord, they entered appearance and they filed an application under Order 39, Rule 4. That was on 9/9/21. And that application, if your lordship takes up for a moment, that is at page 69.
Yes.
Now, this application was filed under 39(4) to vacate the ad interim order. And the basic premise was paragraph 6 at page 72.
This was by the defendant.
This was by the defendant.
Paragraph.
Paragraph 6 at page 72.
Yes.
Now, they alleged, my lord, that the petitioner, while laying the petition for grant of temporary injunction, has misled the court into understanding that they have possession over the suit land, whereas actually they do not have any possession over the suit land and hence not entitled to any injunction of whatsoever nature, either permanent and or temporary, for which the said order dated so and so is liable to be vacated. In this regard, it is stated that the plaintiffs have suppressed the material fact that this petitioner is the recorded owner of the scheduled land which she had purchased by her which had been purchased by her from Rotneswar Malakar by sale deed number so and so, and thus fact was clearly known to Gita Malakar and Nitya Malakar as well as the other co-petitioner who thus cannot have any claim over the suit land. Then at paragraph 8, my lord, they say that they disclose about the sale deed, that we have a sale deed in our favor, and they say that the petitioner, that is us, we do not even have any possession, and therefore we are not entitled to any ad interim order of status quo.
Yes, Mr. Chaudhary. We are proposing to pass an order
My lord,
because we have heard this matter,
my lord.
that we try to balance the equity. We try to protect the interest of both of us. We have seen the photograph which he has annexed. We would not like a complete ban or complete restriction. He can go ahead with the construction. The interest of the court or the parties is that the third party rights, even in the form of tenancy, should not be created. Number one, constructions undertaken would be subject to the final outcome of the suit, obviously. And obviously alienation, those part will not even come. And we'll request the trial court to expedite the procedure and have a final early.
My lord, as regards the tenancy part, my lord, this entire property, my lord, the land has been, my lord, now transformed into commercial land. It's a commercial building, my lord.
No, you go ahead with the construction. We have seen the construction is half done,
my lord,
which is also affecting you perhaps.
my lord.
You want to finish the construction.
Finishing at the same time, my lord, to recover the money, my lord. So if we do not let it out on tenancy, from where will you recover the money, my lord?
That part, third party rights do not.
Then lordship will hear me. Because on that, in that, over that premises, one portion she is occupying by way of operating that beauty parlor, which we have allowed to let her because she is our sister. Now, my lord, the basic thing which we have pointed out before this court was at that point of time that she wanted a bigger portion, and my lord, we could not give that. And that is how,
This
my
will
lord,
be
this
decided
dispute
by
has
the trial
started, my
court.
lord.
We are not
So,
entering.
no,
We are only adjudicating the injunction part,
my lord.
which there was the injunction for 2 years.
My lord.
Appellate court has vacated. We are not saying that appellate court had no reason.
My lord.
We will not go by the principle of
My lord.
what was it?
Wander versus
Wander versus
Anton.
yes.
No, wonder versus
Or Ramdev, that goes slow. We will not say. They may have some reasons, but we'll try to balance the equities. You also go ahead with the you may
my lord.
go ahead with the construction. Don't get third party rights, and we'll request the court.
Third party rights, my lord, I have given an undertaking that we are not going to sell it or transfer it by.
No, even
our
our tenancy might create a problem tomorrow.
No, but tenancy is a tenancy only. But tenancy
We know
suppose even
tenancy.
tomorrow. No, but
How many cases you are involved as a tenant? Even after an eviction order in the High Court, the Supreme Court.
My lord, right doesn't go to a tenant, my lord. Now, kindly see, if lordship is inclined to balance the equities, my lord, I have to repay the money. Tomorrow, my lord, I'll be up before the surface.
We'll request for an expedite. What is the stage of the suit?
Stage of the suit is now, my lord, in the suit, they have filed. It's on a step before preemptory hearing. So it's a very early stage now, my lord, because now, my lord.
When was the suit instituted?
21.
21. 2 years ago, we will request. Nowadays, there is no problem in disposal of a suit. And if there is any problem, you come before us. And we'll have a.
That is the problem I'm setting. Otherwise, my lord, because lordship kindly see, my lord, why I have prayed, my lord, that even, my lord, this injunction, my lord, injunction could not have been granted because of the reason, if your lordship kindly see the counter which I have filed, my lord, at page 137.
137.
137. Since 2019, my lord, that building was erected, my lord. It had come to that stage. And at that stage now, my lord, even after delay of so many years, they came up only with a view to harass
See,
me.
to complete this building, you will need at least 6 months.
My lord.
We have seen.
My lord. No, my lord, the lower portions are ready, my lord. That at least
the lower portions we have seen.
In the lower portion, at least there is 2 shops, my lord, which are ready to be let out, my lord. Kindly allow that because that lower portion, the ground floor is ready.
You open shop of your own, run it of your own, don't let out.
I am not a, my lord, businessman as such, my lord, to run it on my own, my lord.
You run to your own person.
Because lordship knows, my lord.
You run through your own person.
But that will also be through tenancy only. So kindly don't, my lord, put an embargo on that, my lord. Otherwise, my lord, I am amenable to whatever, because, my lord, whatever lordship money falls from your lordship's mouth, my lord, kindly do not put an embargo on that, my lord. At least let me also survive. But tomorrow, man, this thing will become again a matter before the surface courts, my lord. Because of non-payment, and lordship knows, my lord, how stringent those laws also are, my lord, today.
In fact,
This entire, my lord, suit has been prepared only to cause that harassment to me, my lord, to deprive me, my lord. Because, my lord, whatever it is, my lord, Rotnesh Govindo and my lord, the brothers, Rotneshwar and the other one, my lord. It is not that I have, my lord, occupied the entire lands by way of that building, my lord. Some lands are still there. So, my lord, it's a matter of partition, my lord, what will come out, what is not there. And at least, my lord, for that part of Rotneshwar which he has, my lord, given away by way of that, my lord, sold it.
Okay, we will.
In fact, my lord,
Third, we did a then it counted for the petitioner. Also heard the authority. Then it counted for the respondent. Considering the facts and circumstances of the case, and since the contesting parties are represented, this court is of the view that instead of keeping this keeping this petition pending, the same is required to be disposed of, which has been done today. Full stop. The petitioners were the defendants.
plaintiffs. We are the plaintiffs. my lord.
Sorry, petitioners were the plaintiffs in the suit which was filed for declaration of right, title, and interest and partition. Full stop. It is the case of the petitioner as submitted by Sri Dekha that along with the suit numbered as title suit number 28 of 2021, Mistake case number 28 of 2021 was filed under Order 39, Road 1 and 2, CP for injunction. And on 1/3/2021, the learned Munshi Amin Gao had passed an order of ad interim. The matter was thereafter taken up for consideration, and after hearing parties on 22/3/2020, the learned trial court had passed an order confirming the injunction and has directed the parties not to change the directed the defendants not to change the nature of the scheduled property till the disposal of the suit or until further orders. The said order of injunction dated 22/3/2022 was the subject matter of challenge in an appeal preferred by defendant before Court of the Learned Civil Judge, Kamrup, which was registered as Miss Appeal number 3 of 2022. The Learned First Appellate Court, Learned Appellate Court, by the judgment dated 2/5/2020 had allowed the appeal and has vacated and has set aside the order of injunction dated 22/3/2022. Sri Delta the learned counsel for the petitioners. Petitioner. What petitioner please, petition. One petitioner, isn't it?
Petitioners.
Huh?
No, there are three, my lord.
Petitioner.
In fact, four.
Petitioner has submitted that the role of an appellate court in while adjudicating an order pertaining to grant or non-grant of injunction is circumscribed. The settled law is that the appellate court is required to maintain self-imposed restriction as injunction orders are matters of discretion, and until such discretion is exercised in a manner which is wholly opposed to the settled principles of law or the principles of natural justice, such interference is not to be made in a routine manner. Coming to the subject matter of dispute, the current council has submitted that the petitioners as plaintiffs have a good case on merit, and if the injunction is vacated in the vacated comma, the whole purpose of filing would be frustrated, and therefore he prays for and interfered with the order in 2/5/26. Per contract, each other Senate council for respondent has submitted that that there was no ground at all to pass an injunction order, as there was no prima facie case able to be made out by the petitioners as plaintiff. He submits that there is a registered guilt in favor of the defendant number one, which is not even the subject matter of challenge, and simply by and therefore the same cannot be made cannot be assailed without there being a formal challenge. Full stop. He submits that the defendant number one is constructing a 3-storied house on the state plot of land after taking loans, and if the order of injunction is maintained, he will suffer irreparably, as the loan would is likely to be declared as there will be great difficulty to refund, to repay to the bank. Full stop. By drawing the attention of this court to the, where is your photograph? Page
138.
Page number 138. One 38 and 139.
By drawing the attention of the court to the affidavit in opposition filed on 13/6/2023, 3, Chaudhary has submitted that along with state affidavit, comma, the photograph of the structure which is under construction has been annexed, and the same would reflect that the constructions are at a half-done stage, and with great difficulty, comma, the defendant number one is residing on the third floor, correct? Third floor, second floor, second floor. Even without the same being completed. He accordingly submits that the appellate court, having applied its mind before passing the order date 2/5/2023, comma, there should not be any interference with the state order. There is no dispute that the role of an appellate court with regard to an order of grant or non-grant of injunction is a restricted one, wherein the appellate court should go slow unless a case of deteriorating or perverse is made out. In this connection, one may refer to the landmark case of Wonder versus Santop, reported in Surge, and the subsequent case, including the case of Ramdev Food. What was it? Ramdev Food. Ramdev Food. However, at the same time, comma, this court has found that the appellate court in the impute order dated 2/5/2023 has made discussion which cannot be said wholly irrelevant. Therefore, comma, balancing the equities, comma, this court is considered opinion that interest of justice would be served if the order passed by the appellate court, order of injunction which has been vacated, which has been set aside by the appellate court, is modified in the following manner. At this stage, following manner. The order, the defendants are direct not to change, not to alienate the property in question or change the nature and character of the same. However, comma, considering the submission that the construction is being undertaken after taking financial assistance, comma, there is no embargo.
The loan statement is also given.
No embargo on completion of the construction. Three, Chaudhary prays for further liberty that the property, that part of the property may be allowed to be let out, so that his client would be in a position to refund the loan. This court is of the opinion that instead of the state prayer being considered by this court, comma, a prayer of this nature may be made to the learned trial court for consideration, which may be done after taking all the relevant facts and circumstances into account, and the parties may also be allowed to adduce evidence that regard. This court also proposes also under the facts and circumstances, would make a request to the learned trial courts to take up the matter expeditiously as the suit was instituted in the year 2021 and make an endeavor to dispose of the same by an early.
That I can run my own business there, that will be my lord.
Yes, obviously. There is also no embargo for the defendant number one to run any business from the state premises, which however would be subject to the final outcome of the suit.
No, just one submission, if it is recorded, my lord, where your lordship has said that constructions have been made. My lord, my submission that those were made in violation of the injunction orders, that may be recorded as a submission.
No construction had been made in violation of the
My
instruction.
lord,
of
in
my
fact, there are
injunction
documents,
order.
my lord,
My
just
lord,
as my submission.
Then, my lord, kindly hear me also on that, my lord. Whether, my lord, at least Wander versus Antox applies in this case or not, my lord, kindly then hear me also, my lord.
We are not there,
My lord, I'm not urging the court to offer a finding, my lord,
we have
just
recognized any right. We have not recognized any right. We have just recorded what is. Yes, next.
oblige.
Question appeared. Your procedural contempt. What is the contempt matter? Contempt. Mr. Mr. You're for whom?
I am for the sole respondent. Lordship.
Respondent.
Yes,
What is the contempt alleged?
that is that lordship. They filed a contempt petition. Lordship.
What is the contempt alleged?
In fact, by the last, my lord, there was an order of this honorable court that providing the visitation right. There was, my lord, multiple litigation.
Now, where is that order?
That order, your lordship will find,
Of this court?
yes, the order of this court. My lord, your lordship will come to page, my lord, 13.
1-3.
I have heard the learned counsel for the parties
Hmm.
and given my anxious consideration to the matter.
This
This court is of the opinion that the interest of justice as well as the welfare of the child would be met if the father is also given.
we have read, where is the violation?
My lord, now the operative part, your lordship will kindly allow me, my lord, to read. Visitation right.
We have read this.
Yes, my lord, then. Now, your lordship will come to page, my lord, 17.
1-7.
My lord. Now, this is what the honorable court says, that the handing over, taking over would be before, my lord, the prosecution inspector of the.
Correct.
Now, this is the report, my lord, of the prosecution inspector, 19/10/22. My lord, this is addressed to the honorable district judge, session judge. Subject so and so, sir, with reference to the subject cited above. Now, this reference, your lordship will find in the preceding pages, pursuant to the honorable court direction, my lord, the session judge had directed the PI to, my lord, comply with the High Court's direction.
Hmm.
Then, my lord, it reads as follows, sir, with reference to the subject cited above,
Hmm.
I have the honor to inform you that as per the order dated 5/9/22 passed by the Honorable High Court and the order dated 8/9/22 passed by your honor, that the mother has been bringing her child as per the days and times set by the honorable courts. And now a situation has arisen that sometimes the mother gives her child to his father from her lap. And when the father takes his child in his lap, then the mother tries to pull the child from him and says to her child that your father will take you away. The father even requests the mother of the child to accompany them, but she refuses to do so. As a result, next page, my lord, as a result of which the father of the child has been facing embarrassing situations. Therefore, it is prayed that your honor may kindly be pleased to take notice of the aforesaid situation and oblige. Now, my lord, before my lord, I proceed further. My lord, in fact, what has happened, the backdrop, the marriage, my lord, was solemnized on 2017, 21/10/2017. Now, the child was born, my lord, on 14/12/2018, last part of 18. Thereafter, my lord, barely after 1 year, that is, my lord, 15/1/2020. So when the child was, my lord, hardly, my lord, 1 year old, my lord, the mother left. These are admitted facts, my lord.
No, we are not going into those.
Yes.
facts. We
Now,
are
what
not
has
go-
happened?
Yes, we are not, we are only on the order and your allegation of contempt. Now, has the matter been settled
My lord,
regarding the visitation right, regarding,
my lord, now for last 3.5 years, the father is, my lord,
not on that.
yes.
You are only on the order passed by this court.
Yes.
The
Now,
order,
yes,
present
my lord,
proceedings which arises out of an order.
absolutely, my lord, at page 13, the honorable court has made it absolutely clear that, my lord, the court is of the opinion that the interest of the justice
No, no,
is
that was in 5
Yes.
2020.
first, my lord, Sunday and third Sunday.
And now, is there any difficulty in implementing this order?
My lord,
Right.
we find, my lord's difficulty because my lord, as per my instruction, my lord, in fact, when the child, my lord, is handed over, then there are instructions from the mother that the father will take away. So therefore, my lord, since there are specific directions of this honorable court, if, my lord, the respondent is
We will
aggrieved,
not like to have this matter in the court.
correct, my lord, I was likely to
We'll have
suggest
it
your
in
lordship.
camera. You will have it in the chamber.
My lord, my lord.
You come at around, come at 12 pin.
Obliged, deeply obliged.
Mr. Would not like to have it in the,
Lordship,
these are personal
there
matters.
is no willful disobedience, Lordship.
No, we'll,
Order.
and we may not have need the assistance of the council.
Absolutely
You come,
correct. That would be proper, my lord.
Since the parties are there, we'll like to interact directly.
Lordship.
We'll have it in the chamber.
12, your lordship has indicated.
12 pin.
12:20.
We'll
Okay.
rise now
Obliged, my lord.
for 10 minutes, then
Fine.
you come there. We'll.
My lord.
Our court must facilitate to come.
My lord.
And kindly instruct your client what to say, what not to say.
My lord.
The court process.
My lord, correct.
I have informed BD Das, but he told me that he has retired from this case.
What do you suggest? What do you suggest?
Others are there, but they are not appearing.
What about the government? State? The state respondents are there. Is it order? Can you inform us state council? What is the matter about this? Let us have an idea, then
My lord,
we'll take a final decision.
it is a suit for realization of the dues by the contractor.
You are a contractor.
Yes. And there was a tender, then I was allotted the work. I have done the work. But they made some part payment.
Okay.
And against that, I have filed the suit.
Why the private respondent?
My lord,
Why is the private respondent there? Kushal Kumar Sekhe?
private respondent, he was at that time, he was holding the charge of the executive engineer. Thereafter, his name was stuck up.
Okay,
So he had received some goods from me on behalf of respondent number 3.
so it is basically against the state
Yes, against the
department.
state- against the state.
But we can have the department's counsel, there's not a problem.
Yes.
Why has it been dismissed?
My lord, the trial court,
85,000
trial court has decreed the suit in part. Now against
Your
three-
claim was 85 lakh,
yes,
90,000.
yes,
Okay.
yes. Against 3 issue, I have filed the appeal, my lord. The other issues were decided in my favor.
Hmm.
The 3 issues which have been challenged in this appeal were the issue number 3, 5, and 6. And the 3, 5, and 6 issues were, your lordship will find. Issue number 3 at page 36. Whether the plaintiff is entitled to claim the cost of bitumen amounting to rupees so-and-so with interest. And 5 is whether the plaintiff is entitled to claim the escalation compensation. And 6 is whether the plaintiff is entitled to future interest or any other interest against the defendant. So there was a contract, and in the contract for delayed payment, the interest rate was provided as 12%. The written agreement is there. But the court has granted only 9%. And escalation clause was also there in the contract. And regarding the cost of bitumen, for that only the private party was made as respondent.
Yes.
My lord, it
You
would have-
say that in the contract, there was a clause for escalation also.
Yes. My lord, it would have been better if somebody from the department must be there from the other side.
We try to have a government counsel. I think the public works department is there.
Yes.
We can
PW.
have the standing counsel of public works. We'll do one thing. We'll place the matter again by directing reflection of the name of standing counsel PW.
My lord.
Out to J. Sharma. No. This matter was called up, this matter being item number 1. When called up, comma, while Sri J. Sharma, learned counsel for the equivalent was present, comma, none had appeared for the respondent. Para. Accordingly, comma, the matter was directed to be called up again in the second half. Full stop. Para. The situation did not have improved in the second half. Full stop. However, Sri Sharma, the learned counsel for the appellant, has submitted that the earlier set of counsel who were appearing for the respondent have returned the brief.
My lord.
He has also informed this court that the name of the respondent number 6 has been struck off. And therefore, it is only the public works department and its officers who are parties. Full stop. Para. Because this, however, does not reflect the names of standing counsel, public works department. Para. In view of the above, comma, let this matter be listed again on Wednesday next. Because that day we are not going to hear, it'll be, they'll need to reconstruct.
It may be on Thursday, my lord.
No, we'll have one day so that they can have the copy, because today they are not.
Yeah.
On Wednesday next, by reflecting the names of pending considerability in the cause. We can also informally inform them.
Yeah.
Good day. B Gogoi is there, R Dhor is there.
Yes.
Even Nayak is there.
Yes.
P Nayak. 13 matter we like to expedite whatever is. Yes.
Your Lordship, the learned counsel for the petitioner, Mr. Tel Taluka, due to some personal inconvenience, he is to rush. They
Okay,
requested me to inform.
okay, doesn't matter. We'll have it some other. Pre-AK right. Then its counsel for the respondent numbers 1 to 5 has informed this court that those three L Talukdar, Senate counsel for the appellant was present, comma, he had to leave the court due to some emergency. Due to some personal reason. Full stop. Considering the above submission, comma, Grace is directed to leave this case in the next week.
So the date may be fixed on
on
24/8 if it's convenient.
Tell this case is for admission. We'll have it on Friday next.
Your Lordship, the order was passed for disposal of this matter at
Oh,
the
is it?
admission.
Then we'll have it Thursday next.
Your Lordship, on 24/8, if it's convenient, because they informed me.
24? 24 to August.
On Thursday,
Matter of which year?
2022 it's.
Oh, 24.
Definitely.
So, Gogoi, what is this?
Kindly pass out for timing. My seniors will like, sir.
18 matter.
Yes, Lord.
It's still at the admission stage. Why?
Admission stage. There was a delay possibly because
Okay.
of that.
Can we admit this?
I don't think so.
Hmm?
There is no substantial question of,
There is no substantive.
no, not at all. I'll convince you. Lord.
Is there any question of law at all?
No, not at all.
Not even a question of law.
No, not even a question.
Lordship, let
When
me
can we have?
Lordship, let me call my.
Wait for a while, otherwise we'll have it because we have to rise early. We'll have it on Tuesday next time. Wait for a while. If he comes, we'll take it.
Yes. Hello, this matter, LCR is, my lord, could not be traced out. So, my lord, this honorable court passed an order to compare the certified copy, which has been furnished by my learned friend. My lord, lordship may give one day time. Let it come in the next week any day. In the meantime, I will compare it.
While three A learned counsel for the appellant is present, comma, the respondent insurance company is represented by senior counsel, Sri S. Datta. Sri Datta, however, prays for some time for verification of the documents as LCR, as the LCR could not be readily be traced out.
Yes.
Put the para. He accordingly prays for and is granted a week time. This after for 2010 matter. This on Thursday next.
Yes. Obliged.
I'm okay.
Considering that this appeal is of the year 2010, list on Thursday.
Obliged.
Why orders, Mr. Buddha?
Lordship, in this case, Your Honor, I have preferred an appeal for enhancement of the order dated 11/11/2009. Unfortunately, the LCR has not been received till the by this honorable court.
We'll proceed in absence of the LCR. Have you got the records otherwise?
I got the photocopies only.
Doesn't matter. We are for the other side.
And for the respond number 3.
We passed a
Yes,
similar order because these are 10 pending since 10. An office note says that in spite of best effort, the LCR could not be located.
Yes.
That is not something acceptable, but we have to proceed. We cannot just hold back. Office note dated 17/7/2023 reflect that the learned tribunal has informed that in spite of best effort, the LCR could not be raised up. Third, treaty with the learned counsel for the appellate, whereas Priyas Datta, learned senior counsel, is present for the respond number 3 insurance company. Full compare. You are also there. Compare. In view of the state of its not company, this court is of the opinion that based on the documents put on record or which are available, the court would proceed with the hearing of the case. Full compare. Accordingly, this case for hearing on and considering that this appeal of the year is of the year 2010, list this appeal for hearing on Thursday night.
Obliged.
Yes, ACB matters.
Yes, Your Lordship. Lordship, I have instructions not to press this appeal. The order of the appellate court, Your Lordship, was an amount of 4,42,000 was to be paid in.
And what is their appeal for?
No, they have not filed an appeal. So the house owner, where the incident happened, and AACB, that time now EPDCL, both of us were asked to pay the amount in half, both to share the amount which is to be paid. So they have also preferred an appeal. We have also preferred an appeal. I have instructions not to press the appeal by AACB. We will comply with the order.
Your part was how much? It was on pro rata basis.
It was on a pro rata.
How much was your share?
The order, Your Lordship, will find at page number 103. 4,42,000. I think
50%. And madam, you will also pay it.
No, she's appearing for the victim, Your Lord.
The victim.
No, what about the house owner?
House owner is in item number 9. They have not entered appearance.
Who's there? C. Chakraborty.
Otherwise, Your Lordship, perhaps if a formal application is required, I'll file a formal application. Otherwise, I have instructions not to.
We'll record your submission.
Yes, yes.
Now we are thinking, what about their appeal? Why the pro rata basis? Why not entirely upon you?
Lordship, my handicap is that even the records are not available with me. I had a chance.
It's not a huge amount.
It's not a.
Why this bifurcation? I mean,
because the incident happened inside the residence of this person, Your Lordship, the appellant item number 9. That is why perhaps the amount was likely to be paid on a pro rata basis.
we dismiss the other 44. None appears for the appellants on call so far as RSA 4520 concerned. Whereas the KP Pathak Planning Council ACP is present for the appellant in RSA 154 of 2010. Full stop. MS. What is your name?
B Sarkar.
Your name is there, yes, yes. MS B Sarkar, learned counsel is present for the contesting respondent in both the appeals. Full stop. These appeals, Sarah, these appeals have been preferred against a judgment against
Judgment dated
Right,
14/8/2009
2009.
in title appeal number 2 of 2007.
Against the judgment dated 14/8/2009 passed in, is it 82? No.
Title appeal number 2 of 2007.
Your case?
In my matter, your lordship, in RSA one.
Matter. Same matter, I think.
Yes, item number 10, the judgment, the operative part is at 103, your lordship, page number 103.
No, you said the RFA was 82 of 2004.
RSA 154 of 2010.
This, at first, this is filed before the Honorable High Court. Thereafter, it is transferred to the
Yes.
District Judge of Korimganj. Thereafter, renumbered, title appeal number 2 of 2007.
2 of 2000.
If you kindly give the number, has been preferred against a judgment and order dated
14/8/2009
14/8/2009
in title appeal number 2 of 2007.
in title level number 2 of 2007, within bracket renumbered. The suit was instituted by the present respondent for damages due to death of that caused on electrocution on 1/7/2000. Para. The learned court, learned trial court has directed payment of an amount of rupees 4,42,000, right?
Yes, the appellate court.
What about the trial court?
Trial court held in our favor, your lordship. The suit was dismissed.
It was a reversal judge.
Yes.
The suit was initially dismissed. Thereafter, the learned appellate court had reversed the judgment and had directed to pay an amount of rupees 4,42,000 and has divided the same between the AC and the owner of the house. The KP Pathak, the learned standing counsel, ACP Harvard, submit that taking into facts and circumstances and also taking into the background facts and circumstances and also the fact that sufficient time has elapsed and that by electrocution was otherwise not disputed, he would not like to, he has instructed not to press the appeal. So far as the other appeal, namely RSA 45 of 2010 is concerned, as observed above, there is none to press the appeal. Even on the earlier occasions, there was no representation on behalf of appellant in this appeal. Therefore, while RSA 154 2010 is dismissed on withdrawal, RSA 45 of 2010 is dismissed for non-petition.
Obliged.
Yes.
May it please, Your Honor. The decree of reversal I am the defendant. The respondent herein has instituted a suit for right title interest.
Appellant is the defendant.
Defendant.
Suit
Uh,
for
Suit for right title interest, recovery of possession, and partition.
yes.
The Concourse was the original owner of the suit land. Concourse. The family tree is necessary here in Concourse was the
Have you given the tree? Have you given the family tree here?
no. The Concourse was the original owner of
Name.
Concourse.
Con.
Con. Coach.
Court. So yes.
He was the original owner of 3 bigha, 2 katha, 8 lechas of land.
Yes.
Having 2 sons, 1 daughter, and the wife.
5. Son 1.
2 daughters.
1 son.
2 sons.
2 sons. you said.
Two sons, one daughter,
1 daughter.
and wife. Sons are Ram, Tilak. Ram and Tilak are the son.
Yes.
Renu Soikia was the wife. And Meena Soikia is the daughter. So Tilak, the present defendant who are the plaintiff is a successor of
The
Tilak.
present defendant is not the plaintiff. Defendant is the appellant.
Defendant is the appellant. Present respondents are the
Present
plaintiff.
respondent, yes.
Yes. The successor of Tilak. Successor of Tilak. So first son Ram died unmarried.
What are the other name? Son of
Tripti
Tilak?
Saikya
Huh?
and Papu Saikya.
Apu and
Tripti.
Tripti.
Tripti is the wife. Papu is the son of Tilak.
Tripti. Papu Stakov. They are the plaintiff. Then only Tripti remains as the plaintiff.
Yes. So first son Ram died unmarried, and the husband of the Tripti, the Tilak, died in 1985. The Renu Saikya, the wife of Kon Coach, was died in 1999. So remaining person of Meena Saikya is the daughter who is the appellant herein, and the Tripti Saikya. Now dispute arises when they filed a suit, present suit, claiming the entire suit property.
The entire land owned by Ram Concourse.
Yes, entire land was originally owned by Concord.
The entire land is the subject matter of the suit.
Yes, they have made it, and not entire matter. One.
You said it was 3 bigha, 2 katha, 8 lechas.
8 lechas of land. Then they have made.
What is the suit land? How much?
Suit property is 1 bigha, 15 lechas total, and
1 bigha,
15 lecha in the schedule A, and 2 katha 15 lecha in the schedule B.
Okay.
They have instituted a suit claiming the entire suit land as the ancestor property.
Both schedule A and schedule B.
B. So declaration and the right title interest, and for recovery of possession of a suit of B schedule land where we are residing and having a RCC building over the suit land.
But this will not be total suit. The entire, this 1 bigha 15 letter, you said.
Now, some of the portion were sold out earlier. For subject matter as per their claim, that is 2 bigha, 1 bigha,
15 letter.
15 lesser,
And
1.
3 katha 15 letter.
Yes.
That means this will amount to be 1 bigha 3 katha 10 letter. Total. Isn't it?
1 bigha,
1 bigha 3 katha 10 letter.
yes, 3 katha 10 lessers. This is the subject matter of the suit line.
Yes, thereafter what has happened?
They've instituted the suit claiming that the entire suit land, which was ancestral property, and the suit land with the RCC building over there, the C schedule, B schedule land, is the ancestral property and has been given by her mother-in-law to the plaintiff. And as far they have claimed that the suit property has to be partitioned and the recovery of possession regarding the B schedule land. Initially, suit has we have contested and we filed our WS as stating that the out of that scheduled land, 2 kathas of land has been gifted to the defendant.
You said that.
Yes, that is our case. 2 kathas of land has been gifted to the daughter.
By whom?
By the mother. Mother is Renu Saikya.
Two katha gifted by mother.
Mother Renu Saikya. To the defendant.
To Meena.
Meena. The suit proceeded and the after trial, suit has been dismissed. They preferred an appeal. On appeal, the judgment has been reversed. Against that, they present.
This dismissal suit was by how? Registered? The gift deed.
Give to the register.
Registered.
Register. This is exhibit Kha.
Oh.
Exhibit Kha.
Suit dismissed then. Appeal.
Suit dismissed, appeal, it was reversed and therefore this present appeal. So, now I read the judgment. The appellate court judgment. Started from page 31.
Yes.
The appeal has been directed by the plaintiff against the judgment and decree by the learned Munsif number 1 Nagaon entitled to such and such. The ground for appeal is that learned trial court are both in law and fact impugn judgment and decree is hit by section 20, order 20 rule 5 of the CPC failed to appreciate a proper evidence on records. Learned trial court has not dealt with the issue number 5, 6 and 7 properly and not decided the same in accordance with the evidence on record, as well as law involved decision of the trial court in the issue number 5 is against the law and not accordance with the provision of section 9 of the Hindu Succession Act 1956. And decision of the learned trial court is against the Hindu law of succession and therefore judgment and decree passed by the learned trial court is liable to be set aside. Appellant as plaintiff filed the suit for declaration right title interest recovery of first position and for partition for permanent injunction against the respondent. Land measuring 1 katha 15 lesser of Dag number 304, 4 katha covered by Dag number 305, 2 katha 15 lesser covered by 308, total 8 katha 10 lessers of patta number 88, whole 50 patta number village such and such under Nish Shahar Moja along with the Assam type house in the suit land, the suit property of the plaintiff share. According to the plaintiff, the suit land, the suit property falls to the share of the plaintiff. Plaintiff pleads that the suit patta land belong to the Dono coach, Moina coach, Kon coach, all son of late Fatik coach, and they have equal share of 1/3 land in the Dag of the suit patta. During 1968-69 settlement period, old BP patta number such has become a patta number 88 with 3 ducts, 304, 305 and 308, having 10 bigha 2 kata 6 acres of land of duct number 208 of old patta PP number 55 with left out PP number such and such in 1969 settlement. In 1968-69 settlement, the suit patta number 88 remained in the name of Bruno Coach, Mona Coach, and Con Coach died. His legal heirs, namely Tilak Soikia, Ram, it will be Ram, Meena Soikia, daughter, and a wife, Renu Soikia, inherited the share of the Con Coach. They become recorded pattadars of the suit patta. On the death of Con Coach, his two sons, namely Tilak and Rama, and his wife Renu and daughter Meena Soikia inherited the share of 3 bigha 2 katha 8.5 acres of land of patta number 88. Rana Soikia, son of Con Coach, died unmarried. Tilak Soikia, predecessor of plaintiff, died on 1985. Renu Soikia and the wife Con Coach died in the year 1988. Thus, defendant number
died in 88, you said 1999.
in the 88, I'm sorry. 88. Thus, defendant number 1, along with the present plaintiff, are the legal heirs of Renu Soikia is to inherit the suit property. It is pleaded by the plaintiff that Renu Soikia, Tilak Soikia amicably divided the property equally from east to west, and northern part falls to the share of Renu Soikia, and the southern part falls to the share of Tilak Soikia. The predecessor of plaintiff, on the death of Tilak Soikia, name of the plaintiff mutated in his share, and the plaintiff become pattadar of the suit patta land. But due to some personal difficulties, they shifted to Amulapatti from the suit patta land, and Meena Soikia, defendant number 1, stayed in the old house with her husband. Defendant number 2, on the death of Renu Soikia, the mother-in-law of the plaintiff number 1 and the grandmother of plaintiff.
Mr. Tiraicha, you tell one thing. You say that 2 katha was gifted by Renu, isn't it? To her daughter Meena. Right?
Yes.
And this was a registered gift deed.
Registered.
What was the source of title of Renu?
Inheritance.
From whom?
Con Coach.
Con Coach. If the source is inheritance, then we have to see whether by the law of inheritance, what would be the share of Renu.
Yes.
See, Ram passed away in 1985. Tilak also passed in 1985. And Meena is the daughter.
Yes.
So therefore,
there will be 3 shares.
Why 3 shares? What about Ram?
Ram died earlier.
Doesn't matter. His share will be devolved as per Hindu law.
That will be 3 shares. The surviving legal heirs.
Ram does not have any surviving legal heirs.
No, he died in 2 years old when he was.
Understood. Who are the legal heirs? Is it necessary that if a person dies without marrying, he will not have any legal heirs?
Mother?
Mother is there.
Yes. Mother is Renu.
That is it. You cannot say that there will be 3 shares.
No, a share of a dead person cannot be.
It is not on death. His share, where will it go? It will go to his surviving legal heirs. Mother is there.
Mother is there.
It will go to the mother, class 1 legal heir. Isn't it?
That has been discussed in the judgment. Only 3 persons are there: the son, who died subsequently after marriage, the mother, and the daughter.
Rana predeceased his mother.
Rana predeceased Con.
No, Renu.
Renu.
No, Ram is the wife of Renu, isn't it? Renu is the wife of Con Coach. Con Coach, you said they had Renu wife, Ram and Tilak sons and Meena daughter.
Yes, Tilak, Renu, and Meena. Where Ram died,
Renu is the wife.
Renu is the wife.
Ram died in 1985.
Tilak died in 1985.
The Ram even died in 19.
Very, only 2 years old before the death of the mother. As per their pleadings, that is the pleadings of the respondent.
Okay, then let us.
Paragraph 5. On the date of concourse, the two sons, namely Tilak Rana and his wife Renu and daughter Meena Saikya, inherited the share of 3 bigha 2 katha 8.5 lakhs and the suit patta number such and such. Son concourse died unmarried. Tilak died unmarried and Tilak Saikya, predecessor of the plaintiff, died in 1985. Renu Saikya, wife concourse, died in 88. Thus, defendant number 1 along with the present plaintiff are the legal heirs of Renu Saikya to inherit the suit property. It is pleaded by the plaintiff that Renu Saikya, Tilak Saikya amicably divided the property equally. From east to west, a northern part fall to the share of Renu Saikya and the southern part fall to the share of Tilak Saikya. The predecessor plaintiff and on the death of Tilak Saikya, name of the plaintiff mutated in the share of the plaintiff became pattadar of the suit property. But due to some personal difficulties, they shifted to Amulapatti Road and suit land, and the Meena Saikya, defendant number 1, stayed in the old house with her husband, defendant number 2. On the death of Renu Saikya, the mother-in-law of the plaintiff number 1 and the grandmother of plaintiff number 2, her share also inherited by plaintiff and defendant number 1. But defendant number 1, during absence of plaintiff, time to time sells some of the land from the plaintiff patta, and when she asked, they vehemently objected. Plaintiff submitted that RCC house falls in the share of the plaintiff and same is under the possession of her tenant. And on 21/6/2005, plaintiff last visited the suit land, and when she was planning to erect her fencing on her share, both the defendant threatened her, denied her right title share on the suit land. Therefore, they have filed this present suit. Defendant number 1 and 2, on receipt of the summons from the court, appeared, contested the suit by filing the suit of the plaintiff, submitted that plaintiff suit is not maintainable, but by limitation hit by non-gender and necessary parties, answering defendant stating that land was originally belonged to Concourse, predecessor of plaintiff, and the answering defendant Concourse died in the year 1961, leaving behind his legal heirs Renu Saikya, the wife, Tilak Saikya, son, Meena Saikya and Rina Saikya, daughter, and Rana Saikya, son. It is stated by the defendant that Renu Saikya died in the year 1999 and Rina Saikya died in the age of 8 years. Rana Saikya died at the age of 2 years. Tilak Saikya, husband of the plaintiff, died in the year 1985. It is stated that Tilak Saikya had no cordial relation with the mother Renu Saikya, and he left the parental house about 35 years back, settled at Amulapatti, Nagaon, and their mother Renu Saikya, who worked in the health department, purchased a plot of land at Amulapatti, constructed a house thereon, gave said property to Tilak Saikya and their mother Renu Saikya during her lifetime, made it clear that Tilak Saikya, without claiming any share
will not claim
any share of her suit patta land, and the RCC house standing on the suit land is constructed by her and her husband. Assam type house was constructed by her mother Renu Saikya. Therefore, plaintiff has no right to claim suit patta land. It is also pleaded that Renu Saikya gifted 2 katha land from the suit dag number 308, TP patta number 88, with the sanding house by the registered gift deed number such and such dated 1991. Upon pleading of the parties, Learned Trial Court found the following issues: whether there is any cause of action, whether the suit hit by principal or waiver estoppel, whether the suit is barred by limitation, whether the suit hit by non-gender or necessary party, whether plaintiff has a right title and interest of the share.
Yes.
Then subsequently, court from paragraph 14, the court has spent some point in the present suit, paragraph 14. After scrutinizing the plain written statement of the respective parties and after scanning the judgment, I find that the main point of determination in the paragraph R1, whether the plaintiff inherited any share in the suit land, took dog and patta land, whether plaintiff have right title interest in respect of the dog and patta land, and entitled partition aspect of their share. Pleading of the parties clearly pointed out that let Kon Soikia, who was the original owner of the suit land, presently plaintiff number 1 and 2 and defendant number 1, Srimati Meena Soikia, are the legal heirs left by Concord. To find out the same, let me scrutinize evidence and material on record. Learned trial court decided issue number 1, 2, 3, 4 in favor of the plaintiff, 5, 6 against the plaintiff, and dismiss the suit of the plaintiff. 5, 6 regarding the whether they have right title interest over the suit land. It is admitted fact that the Concord in the owner of the suit land, pleading of the parties goes to show that earlier suit patta was in the name of Drona coach, Moina coach, Concord. All of the son of Patik at the time of patta number 55 having 4 dogs. During 1968-69 settlement period, new number 88 assigned with 3 dogs. 1 dog is 208 was left out when new patta number 88 was assigned in the year 1969 settlement. It was pleaded by the plaintiff that in the year 69 settlement, suit patta 88 issued in the name of Dono coach, Moina coach, Con coach, all son of Patik coach. Con coach died leaving his wife, son and daughter. Tilak coach, Rana coach, both are the son of Tilak Soikia, Renu Soikia, Meena Soikia, and the daughter of Renu Soikia, wife of all legal heir of Con coach. As for pleading of the defendant, Con coach died in the year 1961, prior to 1969 period, that is settlement period. It has been admitted by the parties that Dono coach, Moina coach, and Con coach inherited equal share of land dark number 304, 305, and 308. In the dark number 304, each brother got 3 katha, 11 lesser, 1 by 3 lessers, 11 by 1 by 3rd lessers in dark number 305. Each of the brother got 1 bigha, 3 katha, 9 and 1/3 lechas of dark number 308. Each of the brother got 1 bigha, 8 katha, 1 by 3rd, 8 and 1 by 3 lechas of means according to the party's share of concourse in the suit dark number 304 is 3 katha, 11 and 1 by 3 lechas. 11, 7, 11 1 by 3 katha. In dark number 305, 1 bigha, 3 katha, 9 1 by 3 length, and a length of dark number 308 concourse have 1 bigha, 8 and 1 by 3 lessers of land. Thus, the share of the concourse is 3 bigha, 2 katha, 8 by 2 by 3 lessers of land. PW1 plaintiff in her evidence deposed that claim land originally belonged to the father-in-law Concord. He stated her mother-in-law Renu Soikia died in the year 1999 and her husband died in the year 1985. She stated that her mother-in-law purchased the land of Amulapatti where she is now staying. And her mother-in-law worked in the civil hospital. She has no knowledge how suit land was occupied and possessed by her in-laws family prior to her marriage. And from the year 1987, she permanently settled at Amulapatti. From 87, she was permanently settled in Amulapatti. She stated Assam type house was constructed prior to her marriage. And she do not know who had constructed the same, and subsequently her mother-in-law constructed one RTC house over the suit land. And construction was completed prior to her death of her mother-in-law. And now RCC house was let out by tenant, by defendant for last 10 years. Her evidence is that all the houses over the suit land is constructed by her mother-in-law. Evidence of PW2 Hogan Mandal is the newly Mandal is that newly constructed RCC house was constructed about 10-11 years ago and is the old Assam type house. Defendants still living. Evidence of PW3 Palas Soika is the one once Mandal visited the land to measure the suit land, but plaintiff did not allow. He further deposed that on the suit land there is a Assam type house and 2 tin shali roof house those houses are constructed during the lifetime of Renu, the mother-in-law of plaintiff number one. The mother of defendant number one in cross, he stated that he doesn't know who had constructed the RCC house. Evidence of DW1, Meena Saikia, the defendant number one, is the RCC house is constructed jointly by her mother and by her husband, and they are the owner of RCC house, which they let out to the tenant. She deposed her mother gifted 2 kathas of land of Dag number 308 by register gifted dated and delivered possession, and accordingly she is possessing the said land with Assam type house, which is bounded by North Himal and Gulab Saikia, south her mother's own other landed but now in her possession. East land is in her possession, west is road. She stated her father got 2.5 bighas of land. She stated that Tilak in her brother Tilak is her brother and plaintiff number one, Tripti is the wife of Tilak. And plaintiff number two, Bapu, is the son of her brother Tilak, and Tilak died in the year 1985. And her mother Renu died in the year 1999. She stated that she hasn't filed any document to show that she has incurred rupees 3 lakhs for constructing RCC house. In cross, she stated that he had sold 2,000 of land to Bapu, 2 kathas of land to Bipul Das in other white registered sale deed in the year 2002, which is behind the Assam type house. She denied that the RCC house was constructed by Tilak and southern part of suit land belonged to Tilak. She also denied that half of the land of Dag number 308 belonged to Tripti and Bapu. On scrutiny of evidence on record, it has been appeared that suit house is constructed by the mother-in-law of plaintiff number one, who is the mother of defendant number one. Plaintiff praised share in the suit property, claiming half of the land, the suit property, citing that she inherited the same from husband and her mother-in-law. From the evidence, it appears there is no amicable partition done between the parties. Land measuring Dag numbers 304, 305, 308 belongs to Dono Coach, Moina Coach, and Con Coach. And Con Coach is the ancestor of plaintiff and defendant number one. Pleading of the parties reveals that the Con Coach died prior to marriage of plaintiff number one with Tilak Saikia, who was the son of Con Coach. That means at the time of Con Coach, he left behind his wife Renu Saikia, defendant number one Meena Saikia, and the Tilak Saikia as legal heirs. Other 2 children of Con Coach died during childhood. Plaintiff claimed her properties by right of inheritance and stated that by partition she got a share of mansion in Schedule Q. Evidence on record.
When did Con die?
Con died in 1961. He died in 1961.
Cannot be. Because one of the Ram has died at the age of 2 years, you said.
That was the pleading. That was the pleading by the plaintiff.
No, Ram died in the year 1985, isn't it?
No. Tilak died. Tilak.
And Ram?
Ram died in the childhood.
When was it?
Proper year was not mentioned, but it was mentioned that he was in 2 years old.
2 years old.
2 years old.
You said 1985.
85 is the Tilak.
85 we have recorded.
85 is the Tilak, the husband of plaintiff, who is the son of the Con Coach, and mother Renu Saikia died in 1999.
Tripti is the husband of Tilak.
Tripti is the wife of Tilak.
Wife of Tilak.
Tilak.
Papu was the son who has been struck off.
That was struck off.
Okay, we'll have to continue some other thing. So, Doctor, your matter perhaps. Yes, madam. What was it?
Some other day not possible, perhaps we will.
What was the matter?
Can we lordship fixed on 1st August?
Yes.
1st of August. Item number?
Item number 5.
Then on 2nd August, Lordship, 5 August, some matter of this, 2nd August. That's a problem, do you know?
What was the matter about?
Lordship, plaintiff suit, Lordship, I am the plaintiff appellant, Lordship, concurrent pending.
What was the suit for?
Right title and interest, Lordship,
Recovery
not recovery,
Not record.
only right title.
over
Over the suit land, Lordship, ancestral property, Lordship, both sides are brothers,
confirmation.
confirmation.
They have said an ancestral property. they could
Confirmation
not-
of position. Now it has been executed.
No, they
No.
could not prove that. I'll
No, it
appeal
has
it.
been executed now.
No,
the
no,
decree.
land is with me, Lord, with us, Lord.
Oh,
No.
Execution proceeding has not started.
No.
No, that position is not correct. We have been in possession of the land till date. And it's not a ancestral property, my lord. They could not prove that. And both the courts held that it's not a joint property.
It's in your position.
Yes, in our.
Why the confirmation then?
There is no recovery of, in prayer, there is no
confirmation
recovery
position,
of.
There is no prayer.
No, why they have asked for confirmation of position?
In prayer, there is no confirmation
That
of
prayer is
position.
not there at all.
Yes,
You want
in
to
fact, no, not
They
recovery
have
of
to for
position.
degree for confirming your position.
Right title and only
For,
title
for you.
for me possibly.
Okay.
My lord, your lordship may make an endeavor so that it can.
Yes.
Case can be
Let us see.
adjudicated on that.
On second,
Yes, Lord.
Yeah, better, my lord, third, because this Thursday.
Yes, Lord. Third.
third. This is item number,
Five.
and this matter, when will it take? This will
Obliged.
take some time, Decker.
Lord, can have it in the first week of August, my lord, 8th of August. Is a Tuesday, my lord.
We can try on the same day, 3rd of August.
3rd of August.
It was 3rd.
Your Lordship,
Mrs. Siraj, sir, 3rd of August. Others, is
Your
there
Lordship, item number 12, maybe fixed on 10th of,
he'll give this. Any matter where interim order is to be extended,
10th of August.
he will request the court master, he'll give this. Any matter where interim order is to be extended,
Your Lordship, for item number 24 and 25, the matter may be fixed on 17th
he'll
August.
give the date, don't worry.
Obliged.